We've come across jewellers' protection services before in a previous case note where they forgot to wire a skylight and millions of dollars of artwork was stolen. In this case, they were engaged by a fur coat trader to install a security system in their new premises. Just as in the previous case, the contract included a clause exonerating jewellers' protection services from any claim against it based on negligence. You guessed it, not long after the system was installed, thieves broke in and stole $300,000 worth of valuable furs. The alarms didn't go off. Gutter Furs sued. They knew they couldn't succeed in negligence because of the exculpatory clause. In New York, however, you cannot exonerate yourself from gross negligence. So they sued on the basis that jewellers' protection had been grossly negligent. They brought expert evidence that they alleged demonstrated that jewellers' protection hadn't just done a bad job, that it went beyond that, and that jewellers' protection had been recklessly indifferent to the possibility of a break-in resulting in losses to Gutter Furs. Unfortunately, we know from other authorities that gross negligence doesn't just mean particularly high negligence. It is a different type of negligence, not just a different degree of negligence. The evidence brought by Gutter Furs, even if it was all completely true, only pointed to the degree of negligence. It was pretty clear jewellers' protection had done an awful job, but it was normal negligence. There was no evidence to negative the proposition that they had simply done a bad job while trying to do a good job. As a result, the action by Gutter Furs failed. The court said, plaintiff's assertion of gross negligence is based on its expert's opinion that there should have been 2 motion detectors instead of 1 on each level, a shock sensor should have been installed, defendant should have ascertained how the inventory would be arranged, and a post-occupancy inspection should have been undertaken. Taken together, these allegations do not raise an issue of fact where the defendant performed its duties with reckless indifference to the plaintiff's rights, and thus the contractual exculpatory and limitation of liability clauses are enforceable. It remains the case that liability for gross negligence cannot be excluded under contract, but that gross negligence requires intention or reckless indifference.